Okay. Hi, everybody. Good afternoon, and thank you for joining us today. Again, my name is Tiara Rogers. I'm a hotline specialist here at Housing Court Answers. We're going to have a presentation today on Fheps, and Mr. Zach Hudson, Susan Bond, and Vanessa Adebite of Legal Aid will be headlining the presentation and a workshop on Fheps. The presentation is going to cover the qualifications, how those who are eligible can apply, and what advocates can do to help their clients navigate the program. There will also be some updated information and changes on the program. We're going to be recording, so please ensure your microphones are muted during this time. There's going to be a break about halfway through the presentation. If you have any questions, please drop them in the chat. We'll have room and we'll definitely answer them, but please keep them general. We're not going to answer any personal questions pertaining to ongoing cases. If you have any personal questions pertaining to ongoing cases, you can reach out to us on our hotline and we'll drop that on the chat. And without further ado, I will introduce, let the presenters go. Thank you once again.
Hi, good afternoon, everyone. My name is Vanessa Adebite. I'm a staff attorney with the Legal Aid Society, as Tiara mentioned. I've been with the Legal Aid Society since 2017. Hi, Carmine, I see you on here. That's my supervisor, my first supervisor. I'll allow Zach and Susan to introduce themselves as well.
My name is Zach Hudson. I am a housing attorney in the Bronx as well, and I joined the Legal Aid team in 2018.
And I'm the old lady of the group. My name is Susan Bond, and I've been part of the Fheps team since, which used to be called the Jiggets team, since 1994. And we have in our PowerPoint, we have the emails of the team members in every borough. And so feel free to email the team in your borough if you have questions any day of the week.
Yes, thank you, Susan. Will someone
before we go forward, could I just introduce
will someone be bringing up the PowerPoint for our presentation? Tiara and or Jessica.
Mm-hmm.
Okay. While we're working that out, I just also want to just kind of go over what the objectives of today's presentation are, in addition to what Tiara has mentioned, obviously to inform you all about Fheps, but just to review the 7 major eligibility rules for screening at intake, review why it's harder to move with Fheps in the community, to study the lesser known rules needed when settling a case, filling out a Fheps application, and also just to review the recent updates to the program rules. So as you guys all see, this is just essentially the first page of our PowerPoint, which just gives our email addresses for those who are presenting today. But we do have Bronx Fheps team member.
Sorry, you want to mute.
Okay. So this is just the email address for those who are presenting today. But again, as Susan mentioned, we do have Fheps team members in each borough. So feel free to reach out to those who in those specific boroughs and or just the team generally. We can move on to slide 6. Okay, so what is Fheps? So Fheps is actually just the acronym for the Family Homelessness and Eviction Prevention Supplement. So next slide. Fheps is a rent subsidy. So just simply, Fheps is a rent subsidy program, and is eligible applicants will receive an ongoing rent subsidy to cover their rent. It can be used to pay arrears if the applicant intends to stay in their current apartment. And it can also be used for those who wish to move, but we'll get into that and those nitty-gritty details a little bit later. But again, it is for those who have cash assistance through the HRA. Some people refer to as welfare, but yes. So if you do have cash assistance, you may be eligible for Fheps. if there is a minor child in the household. We can move on to the next slide. So there are two types of Fheps. There's Fheps A, which is an entitlement, and then there's Fheps B. So Fheps A, there's Fheps A to stay, and then there's Fheps A to move. So some of the legal providers throughout the City of New York, including the Legal Aid Society, for instance, is one of the organizations that is allowed to complete a Fheps to stay application, and that helps pay not only the rent arrears for tenants, but then also it helps pay ongoing rent arrears. Applicants need only to meet basic eligibility rules outlined in this presentation. And this is just, again, this is something for you to essentially refer back to after we have gone through the presentation. So you just have a kind of like a quick recap of the eligibility requirements for both Fheps A and Fheps B. So you'll see, we'll outline the differences between Fheps A to stay and then Fheps A to move. And then also for Fheps B, which is limited to 1,000 families, new families per year. So we can move on to the next slide. Sources of law. Depending on where you are, as far as your occupation or if you have interests, generally, these are just essentially where the sources of law that are essentially form the basis for the Fheps program. So there are a number of cases, as Susan did mention. She was a part of essentially the foundational case of Jiggets versus Brinker, which was in 1990. There's Social Services Law 350, Section 1A. We also have the New York Administrative Code, clarifications from the Fheps plan. And then there's also the Fheps plan in 2017 to how to settlement and 2022 amendments. There's also the New York City HRA Fheps policy directives via the Empire Justice. All these things are things that essentially you can Google, and then you can kind of learn more information. Again, these form the sources of law for any argument as to whether or not Fheps is, a valid program, or the legality of the program and its existence and how it operates. So now we'll just kind of go into the 7 major rules of the Fheps program. And again, just the overview of the eligibility for those who wish to receive the Fheps program. So I'll switch over to Susan at this point.
Susan, you're on mute.
Zach, why don't you take it?
Sure. So the 7 major rules. We'll start at the kind of the high level. So first of all, the household includes cash assistance and a minor, meaning that the applicant has an open cash assistance case with HRA. So that is not a SNAP case, right? For food stamps, it's actually cash assistance where they're administering shelter and cash, depending on the budgeting of the case. And that there's a minor in the household, which means in general, someone who is 18 or under, and we'll go into more depth about some exceptions to that. But this is for families with children. The family is facing homelessness or is homeless, and that, the qualifier for that is they're in an eviction proceeding or they're already homeless. So in an eviction proceeding, there's some new, more recent rules that allow us to put someone under Fheps prior to getting into a court case, but the idea is that they're going to be facing eviction because they're not able to pay their rent. The family has at least a 1-year lease or agreement to stay, or the apartment is rent regulated. And why we say or the apartment is rent regulated is because per statute, a rent regulated apartment, there is a guarantee of a lease renewal. So we know that they're going to have a continued right to stay in that apartment. The idea being that Fheps isn't going to be issued for someone where the landlord is going to be able to then, after they are receiving the arrears, then evicting them immediately for some other reason. So that is why the guarantee of at least a 1-year lease. Almost everyone has a share to pay, and we'll go through how that's broken down based off of the composition of the household later on. Normally, the applicant must owe no more than $9,000, so $9,000 in arrears. That was really the rule that was prior to COVID. When COVID, the pandemic started, Fheps increased that amount, and currently it's at $20,000. Technically, that's until December 31st. That's the extension for that $20,000 extended arrears amount, but we're hoping that continues. The city is seeking an extension for at least the next year. The tenant, if they have other resources, they must use the other resources to pay rent arrears. So bank accounts, that type of thing. And then their ongoing amount that they're allocated, the subsidy reflects whatever income they have coming in. So it's a budgeted amount. And then the monthly subsidy depends on factors such as income, immigration status, roommates, budget rules, and more recently, new rules on bedroom, utility, and rent reasonableness. And we'll go through all of those one by one. Next slide.
Should I take that, Zach, and we'll alternate?
Sure, we can rotate through.
So with rule 1, there must be at least one person in the home who's in receipt of cash assistance. And that person could be a pregnant person who has immigration status. So that would be one person. Or it could be a parent or a guardian or a caretaker relative of a minor child. So that could be one person. And there has to be a minor child under the age of 18, or for welfare purposes, you're still considered a minor child if you're under 19 and you're still in high school or its full-time equivalent. So there's various ways you could have a one-person household. It could be a pregnant person. That's one person. It could be mom has no immigration status and there's a citizen child. Could be a citizen parent and a minor child who has no status. So you just have to have one person, but you only get the subsidy for the people on cash assistance. And let me just finish up a little bit on rule 1. The cash assistance case must be fully open for every member who's in the household who's required by law to be on the cash assistance case. So there are rules that if a child applies for cash assistance and mom's a citizen, she must also apply for cash assistance. And if dad's in the house, even if mom and dad are not married, dad must be on the cash assistance case if he has immigration status. Now, right in June, they started sanctioning people for not complying with child support. So nobody in the house can have a work sanction, and they're not doing the work program right now, but they could start it up in 2023. But we are starting to see child support sanctions. So if one of the parents of the child is not in the home, the other parent is required to sue that parent if it's not dangerous to do so for child support. And they sign over their rights to the agency to go after the missing parent. So if the parent won't comply, just says, I ain't going to tell you, HRA is going to say, we're going to sanction you, and they send them a notice, and they reduce the budget of the household by 25%. So if the household's getting $1,000 a month, it'll go down to $750. And HRA won't start Fheps or city Fheps if there's a sanction on the case. And so next slide. So let's just go over who could be in the house, when there's only one person, right? Because it sounds like, what do you mean? If there's a minor in the house, there's got to be a parent in the house or another relative. So it could be a woman with a verified pregnancy. We'll go back. Could be what we call a nice parent, not eligible due to their immigration status, or a guardian with a citizen child. Could be an SSI parent, or a guardian with a minor child, or a child receiving SSI with a parent receiving cash assistance, or it could be a grandparent who has custody, has legal custody through family court of the child, and grandparent could be working or receiving cash assistance or receiving unemployment, but the child could have an open cash assistance case for themselves. So, and just one little question for all of you, when can a pregnancy be verified? So that changed a while ago. For cash assistance purposes, it can be verified by a doctor within the first month of pregnancy, and the person gets a letter to bring to their center, which are now renamed Benefits Access Centers. And they can bring that letter into the center, which says estimated due date, EDD, and mom can then get Medicaid for, or the parent for the child can get Medicaid for the unborn fetus. And when the fetus is born in New York State, then that person becomes a person. The baby becomes a person. So then you have a household, could be then the child is the only household, and you have to wait till the child to be born if the parent has no status, or if mom has immigration status and then has a baby, then it's a two-person household, and you can get Fheps for two people. Next, let Vanessa, oh, there's one more. So if a person's in the home and they're supposed to be on cash assistance and they are not, or the case is not fully open, HRA will not process the Fheps. You kind of have to get all your ducks in a row to help the family clean up their case, get everybody on the case who's needs to be on the case. Sometimes you have to delay a case so a child is born, so you have one more person in the house. So there's a lot of welfare you need to know when you're doing a Fheps case. But now I'm going to hand it over to Vanessa.
Susan,
So,
you went over this slide and answering the question, so we can move on to the next slide. So the second rule, eviction or exception. So one of the second rules is the family must be facing homelessness or be homeless and meet one of the sub rules. So they must reside. So in addition to facing homelessness or being homeless, they must also either be reside in New York City that is subject, reside in New York City residence that is subject to an eviction proceeding, or a foreclosure action that has commenced with respect to the tenant's apartment or building in New York City, or we can move on to the next slide. Or the family is required to leave their New York City residence for health and or safety reason as determined by a city agency, such as district attorney referral or ACS, Children Administration Services referral, or within the last 12 months have been evicted or left a residence in New York City that was the subject of an eviction proceeding, or reside in New York City Department of Homelessness Services or HRA shelter within the last 12 months prior to entering shelter, have been evicted or left residence that had been, that was the result of an eviction case. Families who are homeless or in danger of homelessness due to DV get Fheps B. So one of the And I think the most common thing that we do see, at least through legal aid anyway, is usually those who are facing eviction proceedings. Those are the people that mainly interact with who are eligible for Fheps. So that's, I think, one of the biggest cases that we see. Rule 2, the temporary exception. So OTDA has agreed to temporarily waive the Fheps A eligibility requirement that an applicant and participant must have a housing court proceeding. This eligibility requirement will be waived until at least December 31st, 2022. Instead, the applicant needs to reside or resides within the city of New York, be the subject of a written rent demand threatening litigation in a non-payment case. HRA is not processing holdovers without lawsuit. Submit a declaration of financial hardship form as provided by HRA. So again, one of the biggest cases, biggest class of people that we do interact with, if we can go back to the previous slide, one of the biggest class of people that we do often interact with as regards to Fheps eligibility are those who are facing eviction proceedings. But HRA has actually temporarily waived this requirement. So where the tenant perhaps just simply receives like a rent demand, which is saying like, you have 5 days to pay your rent, or an eviction proceeding will be brought against you. Or essentially there's some declaration of financial hardship. There is a form, if you Google it, you can just see it on the HRA website. There is a financial hardship declaration form. Those are some of the substitutes for this requirement of a lawsuit pending against the tenant to make them then eligible for Fheps. This is really important because again, and we're hoping to actually make this permanent, because again, you shouldn't have to go through a housing court proceeding just to become eligible for Fheps. But we can move on to the next rule, and I'll switch it back to you, Zach.
So rule 3 is again a lease or a guarantee of a lease. So the family must have a 1-year lease to stay from the time of approval if the apartment is not rent regulated. So if it's a market rate apartment, meaning there are no protections that guarantee a lease renewal, if it's just an apartment where when the lease ends, a landlord could evict the person just to reclaim the apartment because that would be their right. That's a market apartment. In that case, we need to see at least a 1-year lease to be able to apply for Fheps. If the tenant is not the tenant of record on the lease, each of the conditions must be met. The tenant of record must have income at or below 200% of the federal poverty line, and the tenant of record must have a lease or residency rights for at least 12 months at the time. Next slide. The applicant must also submit proof of residency in the apartment. So again, this is if your client is not the tenant of record, they have to provide proof that they are a resident of the apartment, and the tenant must also be named as a co-tenant on the lease, court stipulation, or in a written agreement with the tenant of record, giving residency rights for at least 12 months at the time of approval. And the arrears period must match the co-tenancy. So the idea here being that you have to prove that the tenant is liable for these arrears, whether or not they're the tenant of record on the lease or whether the tenant of record, they're attached to that tenant of record and are liable, and that their time in the apartment matches the arrears that you're applying for. Next slide. Susan?
So rule 4, so we're halfway through, everybody. Everyone in the residence, well, we're halfway through the rule, the major rules. Everybody in the residence who is eligible for cash assistance must receive cash assistance or have other verified income. So we talked about if a child is receiving cash assistance, the mother and the father of the child must also be receiving cash assistance if they have immigration status. And all the child's siblings and half siblings have to be in the house. But if Uncle Zach is in the house, Uncle Zach might be working and he would have to pay 30% of his gross income. And so it depends who's in the house. but everybody has to pay a share of their income unless they are what we call a nice person, not eligible due to their income, their immigration status. So if I'm in the house and I'm Aunt Susan and I just bopped over from Ireland, I have no immigration status. I'm on a, then I would be an NEIS person and I wouldn't have to pay a share. So it depends. Everybody has a share except for the immigrants in the house who have no income and have no immigration status. Next slide. So I'm going to throw that to you, Vanessa.
Okay. So the arrears limits. So normally the applicant must owe no more than $9,000. Still and missing checks will not count toward limit. So basically for someone, again, we've said that you do have to have cash assistance, right? So if you've been receiving a number of checks from HRA and maybe some of them have not been cashed by the landlord, or maybe some of the checks went to the wrong place, those checks, the replacement of those checks will not count towards this $9,000 limit, just so you know. But temporarily, aside from that, temporarily until the end of this year, this amount is actually $20,000. So more can be issued for extenuating circumstances. So normally, again, Fheps was limited to, because we said that you can both pay, when you apply for Fheps, you can also apply for the rental arrears, and then also it can assist you in your ongoing rent payment. So the rental arrears were capped at $9,000, but until the end of this year, it's $20,000. And then there also can be more on top of that if there are extenuating circumstances. So the state may allow HRA to pay between $1,000 to $5,000 pre-pandemic. Every additional $5,000 takes higher approval with extenuating circumstances since March of 2020. Home-based money cannot be added to a new applicant. It can cover sanctioned arrears. Again, if you don't know, Home-based does have a small pot of money that they can add on to that of the arrears for an applicant. But again, that money cannot be added to a new applicant application as of right now, but it can cover the sanctioned arrears. I think, Susan, did you want to add on to that one? Susan, you're on mute.
Somebody just asked about what are extenuating circumstances. So HRA looks at things like, is it a low rent? Is it $1,000 rent? That's a low rent these days. Is it a rent stabilized apartment? So the family can stay forever. Is grandma in the house who's disabled? Is anybody disabled in the house? Is it a large family? So they look at the facts of each case and decide, okay, we're going to pay more than $20,000, but they automatically are paying $20,000 right now. And you don't have to explain that there's somebody in the house in a wheelchair, and it's really hard to find an apartment with an elevator. And so right now they're approving everything up to $20,000. If you want, and let's say the arrears are $30,000, HRA is going to want the household to come up with some charity money, but then they might go up to $25,000 if the family comes up with $5,000. And let's say the family owes $40,000 and it's Zach's case in housing court. Maybe Zach can get $10,000 set aside to a monetary judgment, which the family won't get evicted for. But if they ever come into money, they have to pay back the other $10,000. So each case is different. And if you have a client with high arrears, feel free to email the Fheps team and we'll brainstorm with you about ways to come up with some of the arrears and, what what are they likely to pay given the circumstances? But for every additional $5,000, it's a bigger lift to get them to pay it.
Thank you for that, Susan. And the advocate can submit at $9,000 and fix within 6 months, but must update and resign all documents. What exactly does that mean? Essentially, you can cap the application. So where you know that, well, now again, until the end of the year at 20,000, but under normal circumstances, 9,000, where you know that the arrears will exceed that of $9,000, you can submit the application just to kind of get that 6-month grace period and to toll the arrears. And if there's any documents that you can use to update the Fheps application, then any more information you'll have to gather during that time, you'll gather it and then you'll submit it, but then you'll also have to update the documents for the Fheps application along. Yeah, that's pretty much it. So then we can move on to the next slide. So how to deal with the high arrears. So HRA will pay pre-pandemic $9,000, between $9,000 and $12,000 for exceptional circumstances, get documentation, think low rent, long-term tenancy, etc. So this is kind of what Susan just went over. We're talking about what exactly are some of these extenuating circumstances and just trying to be able to inform HRA exactly how and why these arrears did accrue. So some of the things that we, try to harp on is exactly, as Susan said, like the low rent, for instance, where there's a rent of, $900, for example, that's obviously an apartment that we wouldn't want to just simply go to waste in a sense. Or if the tenant has lived in the apartment for, pretty much half their life since their childhood, things of those nature. So until the end of the year, the arrears limits has been raised to $20,000. And again, as we said, more can be issued for extenuating circumstances. Maybe you can get $1,000 or more from client and $1,000 or more from a few charities. Right now, Coalition for the Homeless has less money, which is one of the charities that we oftentimes refer to we refer to our clients to ask for money because they're extremely responsive in requests, but they're not the only charity that's throughout New York City. In some cases, you can get above $12,000 approved for uber exceptional circumstances, i.e. cancer, terminal illness, etc. Essentially, in these Fheps applications, you have to think, how do I best advocate for my client? And what are some of those circumstances that, the application itself doesn't ask you, but it's important for the person who's reviewing the application to know. And as Susan said, you can potentially have the some of the arrears waived. Maybe if there are repairs in the apartment in the form of an abatement, if there are repairs in the apartment that the landlord failed to repair, but they were on notice about, that's, sometimes an argument, or where the landlord took entirely too long for them to bring a case against the tenant for arrears, under the doctrine of latches, perhaps you can say, listen, you're trying to get money from 2000 in this, 2022 case. That's just absolutely unacceptable. Those are just some examples as to how you can try to waive and or sever some of the arrears in housing court. But best practice is, again, just putting in the application at $9,000, even if the case is not settled, so that you have 6 months to resubmit, and then just simply brainstorm how best to deal with the case in that 6-month grace period. We can move on to the next slide. So Rule 5, sample exceptional circumstances. Documentation is a key. Can't just say a person receives SSI. Moving a disabled person from the apartment would create a substantial hardship because family lives near treating source, apartment is on first floor, child progressing in special education, gets individual education plan, etc. So these are just some examples, again, of these exceptional circumstances, right? When, again, the application, the Fheps application, if any of you have ever, seen one, it doesn't ask you about any of this stuff. This, this is why it's important for, us as advocates to, again, make it clear to the person who is reviewing the application that there are some exceptional circumstances that have led to the arrears in the apartment, and why it's important that the family remains in this apartment. And again, another example is just the family has longstanding ties to the community that would create hardship. For example, neighbors babysit, language ties, daycare is close by, etc. Very large households of 5 or more individuals, pregnant women, or 2 or more children under 4. Contributions from community show a community buy-in, not home-based money. So again, where you have the contributions from those who are neighboring, shows again to HRA that this apartment is not just simply, a family or 1 or 2, but truly it's a community that they are a part of. And then we have the next rule, which I'll kick it back to Zach.
I'm gonna, as the next slide's coming up, I want to add on too, because I just saw in the chat someone was asking about ERAP. A couple notes about ERAP. It used to be that you were required to apply for ERAP before submitting a Fheps application. That is no longer the case, but also be aware that it's looking at this point like the ERAP portal will be closing in January. So this is something that we're looking at now, but will not be something that will be kind of an issue later on. But it is interesting that another reason for extenuating circumstances in some of these cases is that these applications were put on hold, Fheps applications, because of ERAP. And then for whatever reason, there was a denial and there was a large amount of rent arrears that went beyond the max. And that's another extenuating circumstance that we've used, sort of court proceedings that have gone on for a long time with stays, et cetera. Note that if you do put in an application to toll, because the arrears amount is getting close to previously 9,000, right now 20,000. The way that it works is that let's say the arrears are at 19,000 this month. You put in the application now, and you're not able to resolve and submit a new application because you don't have a court settlement, let's say, for 6 months' time. Well, if the rent amount is 2,000 a month, 6 more months means you're going to have another $12,000, right? So if you submitted it in 6 months, you'd be submitting an application for $32,000, and that's okay. If you told it now for 20,000 is the idea behind this, is they're not going to look at that extra 12,000. If you go beyond the 6-month mark, which happens sometimes, you toll an application now and you're not able to resolve it for, let's say, 10 months. What we've seen HRA doing in the processing is that they will give you the credit for that 12,000 for that 6 months, and then you have to reduce the charity for the other 4 months out of the 10 to bring it back down to 32,000, basically. So the 6th rule for Fheps is that it is a last resort and should be considered a last resort. The applicant must have no other resources to pay the back rent. So if there's an account that's showing up, or there are roommates, there's some other source of income, that has to be expended first. All roommates also have to pay their share of the arrears. If they do not have the arrears, they need to apply for a one-shot deal, which is a separate grant from HRA, which is recoupable, meaning they would apply for grant money from HRA that they would need to pay back, but that's not available at the time. The family must use their $10,000 resource maximum if they have funds in the bank, SSI money of parents, or any tax return funds. So we do see sometimes we have issues around tax season where HRA is asking that tax refunds be used first to pay arrears before they will contribute additional funds for remaining arrears. There, in other words, must be no other way to pay the arrears or the ongoing rent. And again, this note here about the tax season, it does become an obstacle at times because HRA is aware of tax refunds that are coming in, and clients are asked, and this is for one-shot deals as well, not just Fheps, but are asked to expend those monies first. Next slide. You should determine at intake when you're meeting with your client if there are savings, if there is a tax refund. HRA, again, knows about these things. They can trace anything by computer these days, and clients are not always aware. The government tracks their accounts. And this also includes, when you are opening up a public assistance case, HRA has access to payroll records as well from many different types of employment. So it is important that you get a good sense of where your client's actually at and that you have a conversation with your client about the transparency of their financial situation so that you aren't hooked up on this later on and trying to backpedal, which can be quite awkward. If a client spends a tax return on essential items such as utility bills, child support, orders of rent, that's okay with HRA. Try to keep receipts. Again, this is where you as an advocate are really important in these processes when you're talking about extenuating circumstances, when you're talking about why they shouldn't be looking at money that was spent from a tax return. You're able to explain these things in your advocacy to the person who's reviewing the application, and that can make all the difference. Next slide. Susan?
So right before we started this training, legal aid sent out an announcement that we settled our case with the state about keeping the ERAP portal open, and legal aid is not challenging the state's closure of ERAP in mid-January. The state submitted documents that said they have enough money to cover September, and it looked like most of October. So we are, so the word is everybody should apply, even though there isn't money past October, because maybe there will be more money put in. And maybe people can get money out of it. And of course, they can get an ERAP stay. And so we hope maybe there'll be a lot of political lobbying to get more money from the state or the federal government to put more money in the pot. So it's good for tenants. It's also good for landlords. So we'll see what happens. So Rule 7. Several factors go into figuring out what should the rent be. So the things have changed a lot with city Pheps, and Pheps is now based on the number of bedrooms in the house, not the number of countable people. It first goes by bedroom size. So if it's only a 1 bedroom and there's 10 people, the rent is set by the bedroom size. If there are 5 bedrooms but only 2 people, that's a problem because the subsidy will only cover the 2 countable people. And so that's a secondary rule. So when determining, and we're going to go over this in many of the next 30 slides, how to figure out the rent. So you have to ask a lot of questions. So the first one you're always going to ask is, how many people are in the family receiving cash assistance? Because Pheps, unlike city Pheps, is only tied to the people who have an open cash assistance case. The other people in the house who have SSI or unemployment or jobs, they have to pay 30% of their income generally. But city Pheps is different. Who else is in the home, and do they count for the maximum rent? So we're going to get into that because it depends on who's in the house and what their source of income is, because there's a maximum they're allowed to pay. They're not allowed to pay if Uncle Zach's in the house, he's not allowed to pay more than 30% of his income. And is the family staying or paying their arrears? Or are they going to move from an old apartment to a new one? Or are they moving out of shelter into the community? And what was the old rent? Was it a preferential rent? Was it a regulated rent? Is it not regulated? So all those things you have to ask at intake about to consider how to set the Pheps. And we're going to go through that through the second part of this training. And a little bit more on Rule 7. Was the client receiving a rent subsidy before? So there used to be Fheps without an H and City Fheps without an H. Those programs ended in 2017 and 2018. Now most people, now everybody should be almost in, if they're receiving a rent subsidy, they should have converted to the new Fheps program with an H and to the new City Fheps program with an H. And sometimes we can switch people back and forth if there's a new lawsuit. Sometimes we can't. And we're hoping going forward that both Fheps and City Fheps will work in the future more like Section 8. Section 8 is notified every, NYCHA's notified every fall. This is how much money the federal government's going to give. And then NYCHA has until January 1st when their website changes and says, okay, this is what we're charging. This is what we're charging for a 1-bedroom, a 2-bedroom, a 3-bedroom. And we're hoping in the future Fheps and City Fheps will follow that pattern. But right now, we know NYCHA is not giving that information out to HRA. And so we know that it's not going to change on the 1st of January. But there are city council hearings going on about changing Fheps. And one of the things we hope that there'll be legislation that all 3 programs, Section 8, through NYCHA and Fheps and City Fheps will all change in the future on the 1st of the year. Unfortunately, it doesn't look like that's going to be the case for 2023. But we'll all have to work together to get that to change. All right. Next, I'm just going to go through these charts. These are old Fheps levels that existed from 2019 to 2020 to February 2022. So, for example, a family of 3 or 4 didn't take into account bedrooms could get $1,580 for the rent. So somebody who has a $1,580 rent likely had old Fheps in the past. And if we go to the next chart, these were the Fheps levels that changed in February, and they went up a lot. So for example, a family of 2 now could rent a 1-bedroom, and their rent could have been up to $1,945, and a family of 3 or 4 in a 2-bedroom could have gone up to $2,217 if all the utilities were included. And so we are going forward going to see these higher levels. So right, the Fheps levels went up for a family of 3 almost $700. And likely in sometime in 2023, and then these levels went up again this late summer, early fall. These levels are likely to change every year by a couple of $100 when they go up. So NYCHA will be going up. And so these were NYCHA levels at one point, and there's another chart further along that shows what Fheps is paying now or what NYCHA is paying now. And in January, NYCHA is going to go up, and at some point in 2023, City Fheps and Fheps will follow, and we'll all be lobbying a lot to make them all go up together in the future. So, Vanessa?
Yeah. So when shopping for a new apartment, there are several considerations that one should make. So when approved by City DSS via Homebase for looking for a new apartment, the tenant is given a shopping letter. based on household countable members and bedroom size. If the household is approved for a 2-bedroom for 3 to 4 countable people and finds a 3-bedroom within the 2-bedroom cost, that is okay. So this goes back to the chart that Susan just went over when talking about the Fheps considerations. Previously, it would just be based on, the number of people in the household, and that was essentially in the household income. But now there are other considerations, which include the number of bedrooms in the household, whether or not utilities are included. So again, when shopping for a new apartment, these are new considerations that someone who is trying to get the Fheps application or currently has a Fheps application should and wishes to move to a new apartment, for instance, should consider. The household cannot pay the difference for the cost of a larger apartment above their approved bedroom size. So again, where Fheps does cap the household based on these considerations that we just discussed, you cannot just simply say, okay, well, I'll just take the more expensive apartment and I'll pay the difference. That's not acceptable under the rules for Fheps. We can move on to the next slide. So again, this is just a further elaboration of the rules that Susan went over in the chart. So again, the number of bedrooms is a new consideration. As you'll see, a number of bedroom a household that has 1 bedroom, for instance, and has all the utilities included, the Fheps subsidy can pay up to $1945. But then the number starts to decrease as we go along if there are certain utilities that are not included in that household, which again, you can see in the 3rd column, without cooking gas and electric, then a family of, a 1-bedroom household would have rent subsidy capped at $1835. So with cooking gas only that's being included in the rent, then it'd be $1861 or $1919 with electric only. So again, you just have to kind of have these considerations in mind when dealing with the Fheps application. We can move on to the next slide. Again, so each year in October, these considerations are reevaluated and disseminated throughout.
And let me just add to that. So this past year was a little strange. The federal government decided there was no rent inflation in New York City, which is kind of insane, right? Because we know rents in New York are crazy high. And so they first didn't increase any of the rents for NYCHA or for in New York City in January of 2022. New York City appealed, and as a result, they increased the NYCHA levels in June. They increased the city Fheps levels in May, but they took until October to increase the Fheps levels. And so really, we want all these programs for landlords and tenants to start at the same time, go up at the same time. So the rules are all the same and you don't have to be confused about one program over another. But we're expecting some of this unevenness in 2023, and legal aid may have to sue the city to make them all the same. Vanessa, I'll throw it back to you.
Yeah, we can move on to the next slide, please. So utility deductions, beware. So utility deductions are most commonly for apartments where the tenant pays for their own utility, cooking gas and electric. Unlike Section 8, the tenant does not get a credit to offset their share of the rent. So a family can live in a smaller apartment than their family size. For instance, a family of 5 or 6 can live in a 2-bedroom instead of a 3-bedroom, but the apartment must not cost more than a 2-bedroom with a 5 or 6 utility deduction. So you have 2-bedroom, for example, you have 2-bedroom without gas and electric, which would normally be $2,527, reduced by $23.88 equals $139. But the household will have a higher utility deduction. So that'd be, for example, $3,188 reduced by $30.19, which equals $169. We can move on to the next slide.
So
okay, go ahead, Zach.
So I wanted to throw in a couple answers to the questions that were coming up, because I think everyone should hear these as well. I know that there's some issues with landlords, both not accepting Fheps or city Fheps, and also asking tenants to execute side deals. And I know that those both came up in the question. So in terms of not accepting, and I know that it was framed in city Fheps, and this is Fheps, this is, the city Fheps presentation is on Friday, but it's the same idea, is that if a landlord is not accepting, whether it's Section 8, city Fheps, or Fheps, that is a form of income discrimination in New York. So if you're in a court proceeding, that's something that you can bring up in the lawsuit, that there's income discrimination that's happening. If you're not in a lawsuit and this type of behavior is occurring, if you're not bringing a lawsuit, you're also able to approach the New York City Human Rights Commission. And I've seen that be quite successful. I had a client who was trying to get an apartment with city Fheps, was having a very difficult time. An apartment management company declined and actually said it was because of city Fheps. She went to the commission. There was a decision that was made, and the building did in fact then let her sign a lease for the apartment. So that can be a very effective way of dealing with that. In terms of side deals, I mean, I think, really you should be instructing your tenants that side deals, that's fraud. It is fraud. And, that's something that could affect both the landlord and the tenant. If HOA were to find out about that, they could end the subsidy altogether. And in fact, technically speaking, I mean, we've never seen this really happen, but it could be criminal liability for fraud, because you're taking advantage of a program by breaking the rules to receive that subsidy. So I think that that's kind of a way to talk to tenants about how this is not something that would be acceptable to HRA, and both the tenant and the landlord would be in some serious hot water if HRA was ever to become aware of that. The rent subject to rent reasonableness test, similar to Section 8, all rents must pass a rent reasonableness test, meaning that the rent charge may not exceed other rents that are charged for comparable units in the neighborhood. We're kind of seeing how this is playing out. It doesn't seem to be something that's really being taken into consideration right now, but we are kind of watching to see how this is going to come into play as kind of the new rules take shape. City DSS is contracted with the same vendor as NYCHA. The vendor has a computer program of tens of thousands of comparable apartments and an algorithm to match comparable apartments. HRA is currently retraining staff how to use the algorithm. Advocates are concerned about, when going to court, how to settle a rent increase in an unregulated apartment in particular, because it's an easy argument to say that it is reasonable if it's rent regulated because the increases are by statute. But when it's unregulated, you're in more of a gray area. So we're really watching this. It's not something that we're seeing a lot of pushback on right now, but it doesn't mean that that won't be something that's part of the computation as we move forward. Next slide. If there are more accountable people than the maximum size apartment, the rent will likely pass the rent reasonableness test. So if there's 6 countable people in a 2-bedroom apartment, right? Because really 6 countable people would be entitled to a 3-bedroom apartment. So you can feel fairly confident that that's going to pass the rent reasonableness test. If the apartment is in a high rent zip code, such as gentrified neighborhoods, the maximum rent is likely to pass. Zip codes that are not as gentrified, such as Far Rockaway and East New York, are more likely to have rent reasonableness deductions in the future. Next slide. Susan?
Yeah, sorry. So one of the improvements of Fheps that came about during the pandemic was rent reasonableness, was reasonable accommodations for disabilities. So City Fheps, which is another program that the city pays all the subsidy for, which we're training on Friday, members of the team, always had to rent reasonable accommodation for disabilities. So if so sign up for the City Fheps program, because it's a great training with other team members. So not as good as Zach and Vanessa, but very good. If somebody needs an extra bedroom for a disabled person in the household, and let's say there's a mom and there's a 2-bedroom for mom and 3 children. One of the children is autistic, so that child may need their own bedroom so that they have a quiet place to be at certain times during the day or at night. And so sometimes a family could get a 3-bedroom paid for, even though they would only qualify for the 2-bedroom amount. And the city has a committee that meets to go over the medical documentation for all households who request a reasonable accommodation. And also for other accommodations they might be requested of HRA. But this is one way a family could get a reasonable accommodation. We've had it for also, I had a client where the little girl needed a heart transplant, and she had a lot of medical equipment, and she also needed to go to bed earlier, and she was getting tutored at home because she was too weak to go to school. So they agreed to give her a additional bedroom. So if you have questions about it, feel free to email me and we can discuss the facts. The most important thing is there is documentation from a doctor saying Susan's child needs a accommodation because of what the medical condition is and why they need their own bedroom. So that if you don't have that letter, it's not going to be given. Just saying the child is autistic or whatever, you definitely need a doctor's letter. So next, Vanessa? And we're going to take a break at 3:20.
Okay. So there's Fheps moves, incentives vary. So I know someone did ask about that in the chat, like what are some of the incentives regarding, having landlords accept the Fheps recipients. So Fheps moves from shelters by HRA. So the first month in full and 3 months of the subsidy at lease signing is paid to the landlord. So those, again, this is the first column is regarding those who are moving from the shelter. So the first month and 3 months of the subsidy is paid at the lease signing. There is no signing bonus, but again, there is still other incentives, which include the unit hold incentive equals to 1 month's rent if apartment is held for 1 or more months due to the city. And there's a broker's fee up to 15% of the yearly rent. So those are some of the incentives that can be used to incentivize landlords to accept, someone who is coming out of the shelter with the Fheps subsidy. And then there's the moves in the community by home base via HRA. So similar to the move from the shelter, is the first month in full and 3 months of the subsidy is paid at the lease signing. There is no signing bonus when the recipient is just moving within the community. And there is no 1 month incentive, for those who are moving within the community. But there is half a month broker's fee, and broker may not charge difference and tenant may not pay difference if obtained HRA half a month. So again, HRA will pay half of the month's broker's fee. And then going back to like, you know, this idea of the side deals, again, the tenant is not allowed to pay for the other half where HRA is paying the half. So we can move on. Can the rent be a penny over the Fheps max? This is definitely one of those issues that we run into oftentimes, but negotiation is paramount. In year one of having the subsidy in an unregulated apartment or preferential rent, the rent may not be a penny over the maximum rent permitted for that family based on household composition and income. If rent regulated legal rent increases mid-year, the tenant must pay the difference if they are at a Fheps maximum. So let's kind of like flesh this out a little bit. So where you have an unregulated apartment or a preferential rent, again, the rent cannot be 1 penny over the maximum rent as permitted by HRA. So we go back to that chart where what exactly is the maximum rent, those charts that we kind of went over earlier sets the maximums. It cannot be a penny over. It's called negotiations, right? You know, you inform the landlord, hey, look, listen, you know, this is where my client is, or this is where the tenant is, and they want to move to the apartment. This is the maximum. Can we reduce it if that? So, you know, conversations do go a long way, but in the year two, the tenants must be requesting a rent increase if they have a new lease. Tenants must be requesting a rent increase if they have a new lease, and Fheps maximums are above their new lease. So we can go on.
I would add too that you can, you know, if you're in court negotiating these types of things, as Vanessa said, it's all about negotiation, and you can try to set up a schedule of rent increases. You know, it has to be in compliance with whatever the rent regulation rules are, but so that the increase is in time with the October 1st increases with the rent guidelines board increases for the lease. So you can try to set it up where there is no gap between the max rent that Fheps is providing and what the lease amount is. So they go up in tandem. Does it make sense maybe to break now?
Yeah.
Natural
I think
break in
so.
place? Okay, great.
And so we'll break till 3:30.
Perfect.
Okay.
All right, everybody, grab a glass of water, make a phone call, return a text. We'll see you in a few.
Okay.
We'll get started in just a minute. In the meantime, just while we're waiting for everyone to kind of catch their breath and get back, I wanted to just expand a little bit about the conversation happening in the chat. So when I was speaking before about negotiating a lease so that there wasn't a gap where the tenant had to pay the difference between the Fheps max and the new rent, Yvonne brought up in the chat a good point. Was this in reference to the rent guidelines right now that are somewhat unusual, where there's a 0% increase for 6 months, then the 1.5 afterwards? That is unusual. That's not usually the way these work. And that is something to take into account when you're calculating out what you're negotiating, if you're negotiating a lease renewal. Absolutely, for sure, Yvonne's right. But I actually meant it more generally. What I was trying to say was that every year, the Rent Guidelines Board issue the new rule for how the 1 and 2 year leases can increase. And those go into effect on October 1st of each year. So it's at that point that any lease renewal that happens after that point, the new rules apply. So, if you're trying to negotiate a lease, you might, to maximize the landlord's benefit, and by doing this, read this as incentivize the landlord in a court proceeding, you might want to make the lease renewal begin October 1st if you're able to, because then you're able to increase it to the new max, whatever that might be. But one issue with this is Susan was speaking about how we're looking now at how the new increases for Fheps are happening on the first of the year. So you also have to take that into account just to make sure that there's not a point in all of this where there's going to be a gap where the tenant is paying more. But you want to coordinate your lease renewals with this if you can when you're in court, so that your tenant isn't having to pay extra in that gap. But previously we used to try to coordinate that with October 1st because we knew we could get the increase at that point.
Right. And under the old Fheps rules, the Fheps levels increased every October 1st.
Right, in conjunction. So
right. And we hope it will in 2024 start on January 1st. But we have seen no movement, and it's mid-December that it's going to start January 1st. So we know NYCHA will change January 1st, but we have no idea when Fheps or city Fheps will increase next year. They will follow, they will catch up with the NYCHA increases, but we don't know when, and we don't think that's right. So we'll be working on that next year, probably right after New Year's.
And I just saw Yvonne's follow-up. It looks like we're all talking at cross purposes right now. So you're getting lots of information that may or may not be relevant to that series of questions we were just asking. But moving into the minor rules now. So if we could go to the next slide. The first minor rule is that roommates must pay a share. So roommates who are not part of the mandatory filing unit, and by the mandatory filing unit, we spoke a little bit about this, meaning a child and their parents, brothers and sisters that are minors, that mandatory filing unit, if they're not part of the cash assistance case, they must pay a share of the rent and arrears if they have immigration status. So again, remember, if they're NEIS, they're invisible in the count. But if they're not, then they're a roommate and they have a share. And this rule is very specific. It's that their share of the rent is 30% of their gross income, or their pro rata share of the rent, whichever is lower, right? So if there's 5 people in the household and the rent is $1,500 and the person's income is $2,000, for example, think of it that way, right? The pro rata share of the rent, if you divide $1,500 by 5, that would be $300 per person, right? So you want to look at their income too, and if they're making $2,000, roughly 30% of that income is going to be about $650. So which of those two is lower? The pro rata share. So you're going to want to assign them a $300 share. So you want to give them think of it as you're going to go with the best deal possible for the roommate, right? The best deal possible. So if they have very, very low income, if they're only making $100 a month, then their share is going to be $33, which is their 30% of their income, which is lower than the pro rata. So we'll train more on this later, but the idea in your head, if you're thinking about it, is either 30% of the income or the pro rata share, whichever is the lower, so the better deal. Okay. Next slide, Susan.
So minor rule number 2, right? So we have the 7 big rules, and that's really what you need to know at intake. And these are minor rules to have in your, to look at when you have a case. So Fheps can be processed 2 ways. It can be done either by legal services providers when they're representing somebody, and they can submit applications directly to the Fheps centralized determination unit by an email. And right now, that's the fastest and easiest way to get Fheps processed. So if somebody has a lawyer or paralegal helping them, they should do that. Because what we're seeing is the other way to process a Fheps application is it has to go through the homelessness diversion unit. And a lot of the staff at the diversion units have left. They've retired. They decided they're not doing the job anymore. They've transferred to another unit. So what we're seeing is people are not without a lawyer, and they're trying to get Fheps application done at a center or over Access HRA. It's not getting done. So we recommend, if you work at a legal services office that is a Fheps provider, that's been okayed by the city and the state, then do the Fheps yourselves right now, because we're seeing a real crisis on this, that people don't know how to get their Fheps done. Or if they get their foot in the door and the homeless diversion unit looks at their case, we're seeing sometimes they just give them a one-shot deal instead of processing Fheps. Or they send them away and tell them wrongly to go to home base, which is wrong. So we're seeing all sorts of problems here, and we've tried talking to the city about it. We've tried negotiating with the city about it and the state, and we're pretty fed up. So wait till 2023 to see what we do next. Rule 3, Vanessa?
So Fheps. So the minor rule 3, yearly Fheps increases now in January. So Fheps started, the Fheps with the H, started in December B 2017, and effective February 16, 2022, the state and the city have agreed to increase the Fheps amounts the same as NYCHA Section 8, so they can be commensurate with the NYCHA Section 8 amounts. These are the same for city Fheps and HASA. So while the benefits access centers, formerly known as welfare centers or job centers, might increase the Fheps every certification, we are seeing modifications and restorations are an ongoing problem unless there is a housing case and a certified legal provider fixing things. I mean, honestly, it's really frustrating, to be quite honest, with the number of issues that we have seen surrounding Fheps applications, the recertification of it, or just modifications. But hopefully where there is a legal service provider on the case, or even, those at home base, those at Bronx Works, different organizations throughout the city that help with this, essentially it's left to the tenant to kind of, essentially advocate for themselves, but then also where they do have an advocate, they too should be obviously advocating on behalf of the tenant so that these corrections can be made. But again, the minor rule here is that the yearly Fheps increases are now taking place in January. So we can move on to the next rule.
So minor rule number 4, rent increases for unregulated apartments or market apartments. A lease is required to obtain a lease increase, and now the new rules of bedrooms, utility deductions, and rent reasonableness apply. So basically this is saying, I think there's a typo here, but that a rent increase for unregulated apartments, you have all the rules that come into this for the market apartment. Are there the appropriate number of bedrooms? Are the utility deductions in place? Reasonableness. So even if you had an apartment and an applicant who was approved for Fheps previously, if you're asking to increase the rent based off of a lease increase, then you have to go through the new rules as well for that evaluation.
And minor rule 5. So if you're applying for getting on Fheps and the lease runs from January to December, but it is July, you don't have to get a new lease. As long as there's a rents regulated lease, and it's still a good lease, it's in effect, then that's fine. They can process Fheps without a new lease. It's when the apartment is unregulated, there must be 12 months going forward. So if the lease was January through December and it's July and the client is applying for Fheps, that's going to be a problem. You need to renegotiate an extension of the lease. So it's a year from July.
Rule 6, Fheps modifications and reporting. Okay. Minor rule, Fheps modifications and reporting changes timely. So any change in the family income composition or rent must be reported to the center or on Access HRA within 10 calendar days. If there is a Fheps rent subsidy, a Fheps modification must be filed within 3 months of the change with the FCDU. There's not currently a good system for reporting the change. Failure to report timely bars, arrears, issuance without a recoupment. During the pandemic, this has been a problem. So just again, fleshing this out a bit. So any change in the family income composition or rent must be reported to the center or on Access HRA in 10 calendar days. I mean, honestly, I usually advise those who do receive cash assistance, Fheps, any type of social services subsidies, to always download Access HRA. It's an app. If you do have access to, the app on a phone, perhaps, or an access to a computer that's trustworthy, that's where you can essentially upload in your information and update your profile to let HRA know that there has been some type of change in the income. So whether that's an increase in perhaps, you got a raise on the job, or maybe there's someone who has moved in or out of the apartment. Those are the type of things that must be reported within 10 calendar days. And if there's a Fheps rent subsidy, a Fheps modification must be filed within 3 months of the change with the FCDU. So again, for instance, if you have a lease, a new lease, you must inform HRA of this lease. So that there's no gap in between the period in which they're paying the lower rent amount but you are now responsible for the higher rent amount. So these type of changes in the household needs to be reported to HRA in a timely fashion. Again, 10 calendar days and or 3 months within the change. So yeah. Of course, with everything, there's always, unfortunately, some type of errors in the system. So it's really left with the tenants to be, their best advocate, or where they do have a legal service provider or, organization assisting them, they should be making this information known to them to help advocate on their behalf as well. We can move on to the next slide. So question, counting 3 months. So Connie received a rent increase in December due to a rent stabilization lease renewal. Her new legal rent is well below the maximum rent for her family size. When must Connie report this change to HRA? I'll give you guys like a second or two if you want to write your response in the chat. Thank you all for your participation. We will give the answer if you can move on to the next slide. So December is month 1, January is month 2, and February is month 3, assuming the cash assistance case is open. So if the change is reported in April, arrears will be issued for both for April, March, and February. Who pays the January increase? Who would be responsible for paying January increase? Connie would be responsible for paying the January increase if she's failed to inform the FCDU that there has been an increase in her lease amount. So we're going to be moving on to the minor rule 7.
So this one we are really having a hard time with right now. So if the cash assistance case closes, so the public assistance case closes, Fheps stops, right? This is a different rule for city Fheps, but for Fheps, this is the way that works because cash assistance case, an open cash assistance case is required for Fheps. So when the cash assistance case then reopens on a brand new cash assistance application, there must also be a Fheps restoration application filed with FCDU with a breakdown from the landlord attached listing the arrears that are needed. In other words, if there's this gap that happens in between when the cash assistance case closes and is reopened, you have to do a Fheps restoration. This can be done within 1 year of the cash assistance case closing. You don't have to be in a lawsuit at risk of eviction. During the pandemic, it's ideal to do this for your client. After the pandemic, the homeless diversion unit, HDU at the center, is the one who does this for your client. And currently we're seeing a lot of problems with HDU processing these, which is why it's good if we can do it directly with FCDU in those cases. But that is the process for how you bring Fheps back once the case closes and then reopens. Next slide. Susan?
Sorry, was just looking at a question. So when Fheps, Rule 8, so minor Rule 8. So when you're restoring Fheps, let's say the welfare case closed, so the Fheps fell off the butt, right? Fheps disappears. The household has a year to reapply to have their Fheps restored. So if they have a housing court case, legal aid or one of the legal services providers could do a Fheps restoration application. Otherwise, the household has to request through the homeless diversion unit that they restore the Fheps, and no lawsuit is needed. But since the homeless diversion units are overwhelmed, it's very hard to get Fheps restored these days. So a good homeless diversion unit would say, okay, Susan, let me look in the computer. Oh, I see you had Fheps in July 2022, but your case closed. Oh, I see you brought me a breakdown which shows you July through December, and your case is now open. Yeah, we'll restore the Fheps and send it and add it to the case. There's not a great way to get that done. And so we're seeing often the workers don't know they're supposed to restore Fheps, or they're too busy, or there's not enough staff. So we're hoping in 2023 that some of that will change. In the meantime, if you're a legal services provider, it's better that you do a Fheps restoration application so your client is not hitting their head against a wall. And here's an example. So Beatrice's shelter allowance was budgeted due to work income. She didn't pay her share to the landlord. Her cash assistance case closed along with her Fheps from July to September of 2022 because she had increased income. So she seeks a Fheps restoration in November 22 when her cash assistance case is open. Since she had been on Fheps and she didn't pay her share while she was receiving Fheps, she is gonna get recouped for her budgeted shelter share for January 22 to June because Fheps was budgeted. So people who didn't pay their share while they receive Fheps can get a one shot and have to pay it back if they didn't pay their share and now they're on welfare and they're asking to get that share paid. And we want to tell everybody that only home bases. So I know there's some people from home bases here in the training, but a home base is a not-for-profit organization who has a contract with a city to help households in their zip code areas to make sure to try to prevent them from going into the shelter system, or if they've come out of the shelter system, to help them not re-enter the shelter system. So in the borough of Brooklyn, we have 3 home bases, Canba, Catholic Charity, and Riseboro, and they have different locations, and there's a home base map. So only home bases can process moves for Fheps or city Fheps in the community. So if my lease is up and my landlord brings a holdover against me, I have to move. I would call home base for an appointment and get on their waiting list to get a shopping letter to move to a new apartment. Right now, there's not enough staff at all the legal services offices. There's not enough staff at all the home bases. So there are waiting lists to get appointments. And moves for Fheps can be done because a lease is up and there's a court case, or somebody needs a health and safety move because it's no longer safe in the apartment. And those are the main 2 reasons why people need to move in the community.
So minor rule 9, last child aging out while applying. So as we said, Fheps, right, it's really dealing with, it's really one of the biggest eligibilities is for a minor child to be in the household. So when dealing with the last child aging out and applying, HRA will approve Fheps if there are at least 90 days left before the youngest child ages out. And if there are less than 90 days, but at least 30, HRA will find eligibility if there is a documented plan showing the family can afford the rent after the Fheps eligibility ends. And Fheps will generally end on or about the last child's 18th or 19th birthday. But we have seen it capped on during the pandemic. So, I mean, hopefully it just stays on. It continues forward. But we can move on to the next slide.
Minor Rule 10, Fheps is only for rent. Fheps is a subsidy to cover rent. It does not cover late fees in a court case. It doesn't cover parking fees, legal fees, marshal fees, etc. I mean, for those of us practicing in housing court, we know that those fees aren't enforceable in housing court anyway. And so those should not be counted towards the amount that is agreed for the rent that's owed. They are, however, can be the subject of a small claims court proceeding where they go after those fees separately, where a landlord seeks those fees in a separate proceeding. But this is not something that Fheps will cover. So you can't put that into the application as a request for covering those types of fees. SCDU will process marshal and legal fees in a separate request when the family is out of possession and the landlord has agreed to restore the family to possession. And again, this sort of coincides with how housing court works, where, you know, when we meet with lawyers for landlords, they already know they have to remove all fees. However, if a proceeding goes all the way to the point where a client is evicted and is out of possession, has been evicted from the apartment, there are agreements that we can make to restore the client to possession of the apartment if they pay the arrears in total. And when that happens, the court does allow that marshal's fees and legal fees are included as part of the arrears that must be paid in order to restore them to possession. And that is why Fheps will cover those as a separate item. Next slide.
So Rule 11. Fheps and rent status. So you can have Fheps in an unregulated apartment, a rent stabilized apartment, a rent control apartment, a Mitchell-Lama apartment. You could have it in a Section 236 apartment. You can have it with a Section 8 sticky voucher. You can combine it with scree or dree. You cannot use it in a NYCHA apartment, and you cannot add it to a little known subsidy, which is used for children who might go into foster care. That's the ACS subsidy, which pays a little $300 a month. It was a lot of money in the 1980s when that subsidy came about. It has never been increased. So it's way out of date. So Fheps is better than it was before because now the city is having HASA Fheps and city Fheps the same rent levels as NYCHA Section 8. And we just need to make it in the future all start at the same time on January 1st. Vanessa?
I'm waiting for the next slide. Next slide, please. Thank you. So minor rule 13, Fheps checks. I think we actually skipped this slide.
Oh, did I skip part of Rule 12? Just a reminder, if the family you can't get on Fheps or city Fheps if there is a sanction, but if you're on Fheps and the Fheps is open and active and then the household gets a work sanction, which they're not doing right now, but they may in 2023, or the household gets a child support sanction for not complying with the child support people, the Fheps will stay on the budget, but it will be reduced. So for child support sanction, the subsidy will be reduced by 25%, along with the whole cash assistance budget. And with a work sanction, mom would, let's say mom is the one getting sanctioned, she would be removed from the cash assistance case and removed from the subsidy pro rata. So sometimes you'll see, gee, not the right amount is going out, and you want to get what's called a housing court report, and ask your client about, have you been to the child support unit lately? Have you gotten any notices? Because we're just starting to see that child support sanctions, and when the work sanctions start, it always causes chaos in the rental subsidy community.
Okay, moving on. So minor rule 13, Fheps checks issued by CRPU, Central Rent Processing Unit. So when an application is approved, CRPU should process the Fheps checks in 3 to 5 business days and mail them to the landlord. So again, this is upon the approval, especially when we're asking for rent arrears to be paid with the Fheps application. Fheps move checks are processed by Homebase and currently are sent directly to the new landlord. It is best to pick it up for those organizations who have the capabilities of having those checks picked up and delivered to the new landlord and or having the new, yes. So if CRPU does not issue the amount on the Fheps approval, contact CRPU right away. If CRPU does not put the checks on the budget or sends them to the wrong landlord, contact them right away. If not all checks reach the landlord, have the missing ones canceled and reissued. So essentially, CRPU is the unit within HRA that is responsible for all things Fheps approval and checks getting to the landlord. So where there is any mishap regarding those checks and their acceptance by the landlord, please do contact CRPU immediately to kind of remedy that as quickly as possible. And we can move on to the next slide.
Fheps checks. If there was a problem with the Fheps checks months later, where the checks were fine but then stopped, such as a recertification at the job center, contact the director first and then the regional managers during the regional directors during the pandemic. So that's when there are issues with Fheps checks. Next slide.
Zach, can you answer on the chat what is a sticky voucher? So minor rule 16, time limit. So Fheps is supposed to only last 5 years, except for good cause. And right now, because there's a pandemic, nobody is being kicked off the program after 5 years. In the past, nobody was ever kicked off the program in 5 years. I did just see for city Fheps this week, yesterday, in fact, if somebody's been on the program for 5 years, they ask the person to describe why their city Fheps should be extended. So I have a guy who is legally blind. He can't get any more income. He really can't afford his rent on SSI. So they will extend his city Fheps. So with Fheps, they're not, and they have never tried to kick people off. If we got a bad mayor or governor, could they try to do it? They could, but we've seen people be on Fheps for as many as the child's first year till the child ages out at 18 or 19. And then maybe a grandchild comes along.
So minor rule 17, convert to city Fheps. So households who were previously in DHS shelters system are eligible for city Fheps if no longer eligible for Fheps. A lawsuit is needed. Some other households may fit other city Fheps rules in the community. Most households will not be eligible for a rent subsidy. So talk to your client about their future plan for paying the rent if the children are aging out or your client is going back to work. So again, this deals more so with those tenants who are in receipt of the Fheps, but then maybe a child has aged out, or the child has potentially moved out of the household. These are some of the considerations to be made. We're trying to get another subsidy to essentially take over for the household, and city Fheps is a viable option if they are, if there is a history of DHS shelter in the household. Can you get them SCREE or DREE now? Yes, you can. We can move on to the next slide. But yeah, SCREE and DREE. SCREE is for senior citizens. DREE is for that of those with disability. They just simply freeze the rent. They freeze the rent, and it doesn't bar you. You're not barred from applying for DREE or SCREE where you do have Fheps or city Fheps or these subsidies from the city. screen injury can, again, be added or more so applied to for. Fheps families may qualify for extra bedroom for a very disabled person under ADA. In very limited cases, HRA through their accommodation committee may decide a family qualifies for an extra bedroom if a member can document through a doctor the need for an extra bedroom, such as the need for a hospital bed or a person with autism needing a quiet room. Forms and detailed letter go to the Office of Constituent Affairs. Again, Fheps does now focus on varying categories of eligibility, which does include the bedroom size of the apartment. So again, where there is a family who, and we talked a little bit about this actually earlier, about for reasonable accommodations, and Susan spoke about the need for documentation of the reasonable accommodations. So all of these reasonable accommodations are processed through the Office of Constituent Affairs. And where there is a need for an extra bedroom in the household to perhaps house, supplies for disabilities, or there's a child in the home who needs their own space. If you do provide the adequate documentation, you may, the applicants or the recipients may be entitled to an extra bedroom and still be able to qualify for the subsidy of Fheps. We can move on to the next slide. So there are four ways. To apply for cash assistance. So there's one, to apply through the Via Access HRA online portal and check off that arrears are owed. So again, the Access HRA, it is an app that can be downloaded onto the phone if you have a smartphone. And it is something that can be accessed online, again, through a trusted computer, because you do have to upload a lot of pertinent, sensitive documentation to the system. So just make sure you're on a computer that's safe. So you can do it online or again through the app, and just be sure to check off that arrears are owed, because, we want to make sure that when applying for the cash assistance, you're alerting HRA that there is a need to have arrears paid. You can request a paper application from HRA's info line. The number is provided, or you can download one and check off that arrears are owed. Again, we do have to signify to HRA that arrears are owed and that we're not just simply applying for a one-shot deal, which is just a one-time grant, but instead for the need for Fheps and this ongoing subsidy. For clients with severe impairments and an inability to otherwise obtain Fheps help, you can call HRA's info line. Again, the number is provided, and ask for a phone application for cash assistance and Fheps. HRA is going to contact you for help. And then the last way is you can apply for a Fheps at one of the open benefits access centers. Remember, all applications must be completed by a phone interview that should be done within 7 business days or earlier if there is an emergency. We have been facing a lot of issues recently with people who have applied for Fheps or apply for cash assistance, but they haven't in fact been receiving the phone call. So, I mean, if that is, one of your clients or someone that you do know, please do feel free to reach out to us so that we can help you as best as possible. But obviously also if you do have access to the access centers, you can inform them there, but feel free to just reach out to one of us so that we can help, advocate as best as possible when dealing with that.
Applying via Access HRA, that's honestly probably the most reliable way of getting Fheps applications completed, but requires internet access and technology savvy. So you may need to assist clients in this process. Access HRA, again, is the online portal for clients of HRA. For clients with an open, active cash public assistance case, you go to AHRA account and log in, or set it up if you haven't already set up the account. Select the icon, which should be green, that has cash assistance case and the case number. Select apply for special grant, select I owe arrears. But for clients without an open cash assistance case, you need to apply for a cash assistance case. Select yes to the prompt that asks if you owe arrears within that process. So you can do it at the same time. Next slide. After the above steps, the client still needs to provide supporting documentation. So they have to upload their documents to the account online once the account's set up. New York City HRA document upload app. It's one painstaking page at a time. You need to label each document with the client's last name, the case number, and the phone number, and include a piece of paper that reads, I need to apply for Fheps, but I cannot go to a job center. So that will be your kind of way into being able to apply for it that way. Post-application, HRA will call the client for an interview. HRA makes 2 attempts and then closes the case for failure to complete an interview, and then you have to start all over. So it may come from a strange number, so you should tell your client they should be answering the phone if it's from a private number or a number that they don't recognize. Technically, HRA has 7 business days to complete the eligibility call. We don't find that always happens in that time frame. If you don't hear from them within 7 days, as an advocate, you can also be contacting the various center to let them know that eligibility interview hasn't taken place. Paper application, you can also file a paper application. If you do not have an open public assistance case, call HRA's info line and you can ask for the paper application. The number is on the slide there. You can also download the application directly from the OTDA site. Make sure that you indicate again on the application that you owe rental arrears. It's not enough to just open the application, you have to also indicate that. And if you already have an open public assistance case, you can call the info line and ask HRA to send you a form to apply for back rent. Make sure to ask the info line where to return the form, whether it should be through fax, email, or address, and where to send the supporting documents. Wait for the interview, which is supposed to take 7 business days. Again, it can take longer than that. And then the 2 attempts, and then they close out the application. They should be leaving messages, but again, if your client doesn't have voicemail set up, then that's not going to happen. So really, your client needs to be on high alert for when this is going to happen. If you're in correspondence with the center, you can also try to organize an exact time, and that's more difficult. This is kind of the process for how it goes, and your client really does have to be ready to receive that call. Next slide. You can also apply to the Office of Constituent Services. This is particularly for clients who have a disability or can't leave home for some reason. For clients who have an impairment that render this application via these other means impossible or unlikely, you can call this number and speak to someone, and they will set up an appointment to go out to the person's home and do the application with them in the eligibility interview at the same time. That should connect. It's the center is 90, which is the HRA center that exclusively handles home visits and reasonable accommodation requests. And you want to say on the call, if you're making this appointment, that you need a home visit or help scheduling a phone appointment because you cannot complete an application any other way. And oftentimes this also takes advocacy and follow-up. So at the time of the call, you want to try to get as much information as you can about when this is going to happen. And if the client doesn't then receive the visit, you need to follow up and explain that you've already made this request and that no one actually showed up when they said they were going to, and follow up until it gets done. You can also apply in person at an open benefits access center at the back, or formerly known as the job center. Most BACs are open, but not doing face-to-face interviews. So you can check HRA's website for the open centers clients can go to and ask for help in applying for cash assistance. And or Fheps, but given self-serve computer. This option is not recommended at this time, but it is an option when necessary. It's not recommended because COVID is obviously still a high risk, and as we've seen in the news this week, is even becoming a greater risk right now. This is not over. So especially in public, poorly ventilated spaces like a BAC where there is just many, many, many people all trying to do something at the same time, that's dangerous. And also HRA staff, the numbers are down right now and wait times are very long. So your client could end up sitting there all day long. So it is really better to do this through Access HRA if you can, or Office of Constituent Services for a home visit. Next slide.
So how to apply? So families can be connected to a housing attorney in housing court. Right now, there's not enough housing attorneys, or not enough home bases, not enough staff at HRA. So it's a really difficult time we're going to be going through for the next 2 years to the backlog of cases is completed. While there is a universal right to counsel in housing court, there are not enough housing lawyers. All the legal services lawyers have lost people during the pandemic. Instead of growing, we've shrunk. So we can't possibly cover all the zip codes that need to be covered and represent everybody who needs help. So if people have a legal services provider, hopefully their legal services provider will submit a Fheps application, because that's the fastest way right now to get a Fheps done. Otherwise, clients have to deal with either the centers or by applying on Access HRA, and advocates like you guys who are here should be helping clients after they've submitted an application, making sure they get that interview. If they don't get a call back within 7 days, an advocate should be contacting the director of the center that would be their center, whether they're applying online or in person, saying, Mrs. Cruz did not get a call back. Can you please schedule a call back? She has a case in housing court, and I believe she's eligible for Fheps. And going up the line, going from the director to the regional director and even higher up. And it's going to take a while till everybody gets processed, and till the homeless diversion units and the directors and everybody else are seeing that people get the services they need to not go into the shelter system. So we need all of you to help everybody, and it'll be a hard 2 years coming ahead, but we'll get through it. You cannot apply for Fheps to stay at a home base. You can only apply for Fheps to move. So please do not send people to home bases, because they are very, very short-staffed. They can only do city Fheps to stay and move, and Fheps to move. So we have finished our PowerPoint, and we have a little time to answer some questions. Are there any more questions people want to put in the chat? Oh, there's a long one. Okay, so there's one here. Where should people go if they're not getting through to the welfare centers? They should be applying online or applying in person. It's very hard to get through to the phone to welfare centers. Impossible. And if you're an advocate, you can email a welfare center, but I would not even bother trying to make a phone call. And what else? Transitory income. Only people on cash assistance can get Fheps. So people with transitory income cannot get Fheps. There are budgeting rules for on and off income. Immigrants that have their green cards who live in NYCHA are entitled to have a rent subsidy. You can't have Fheps in a NYCHA apartment, but people with green cards can get rent subsidies in NYCHA, they can get Fheps, and they can get city Fheps. So if you have questions in the future, please email the Fheps team in your borough. Email if there's 2 to 5 names. Email everybody, so whoever is less busy that day will answer the email.
I think I see another question. Let's see.
Okay, so there's an immigration issue. Does the receipt of Fheps or public benefits affect tenants' ability to get citizenship if they are not currently one? We're not immigration lawyers, but generally the rule is if somebody's applied to change their status to get a green card or to get citizenship, they don't want to be receiving public benefits at the time of their interview with the immigration folks. But they're currently, the receipt of public benefits is not hurting people's applications per se, but you really have to talk to an immigration lawyer.
Okay, if that concludes the questions, if nobody else has any questions, I'll just close it out. I just want to say thank you to SAC, Susan and Vanessa, for a very wonderful in-depth presentation of Fheps. Thank you to all the participants who have joined us today. Like they said earlier, we do have a City Fheps presentation on Friday, so I'm pretty sure I'll be seeing some of you there. If you have any more questions or concerns, you could reach out to our website. You can also register to our newsletter, and if you have any questions regarding personal questions pertaining to like cases or housing court cases, you can reach out to our hotline, and you can also reach out to our newsletter and subscribe to any other events coming up for workshops that we have in the future. And once again, thank you to everybody for coming out today. We appreciate the work that you do for the tenants, and thank you.
Okay, goodbye, everybody. Have a wonderful holiday season.
Take care,
Thank you.
everyone.
Thank you so much.